Before I give you your action plan, I want to walk through the 5 biggest mistakes that NC families make that accidentally send their assets into probate, even when they thought they had planned ahead. Mistake 1. Putting assets in a trust, but forgetting to update beneficiary designations. If you have a trust and you have also named a specific individual as the beneficiary of your life insurance or retirement account, that asset goes to the named individual, not the trust. Whether that is what you intended depends on your specific plan. Make sure your estate planning attorney has reviewed every beneficiary designation in the context of your overall trust plan. Mistake 2. Adding a child's name to a bank account to avoid probate without realizing you have made them a co-owner with full legal rights today. If you add your adult child as a joint owner of your bank account, they have full legal access to that money right now, not just after you pass. If your child has financial problems, creditors could potentially reach your account. If your relationship with that child changes, removing them from the account requires their cooperation. Joint ownership for convenience is not the same as a POD designation for estate planning purposes. Mistake 3. Using only a will and assuming it avoids probate. A will does not avoid probate. A will is a document that tells the probate court what you wanted. The court still has to be involved. The process still takes months. The fees still apply. A will is important. It controls what happens to assets that do not have beneficiary designations or are not in a trust. But a will alone is not a fast-track asset transfer strategy. Mistake 4. Never reviewing or updating your plan after major life changes. Estate planning is not a one-time event. Every divorce, every remarriage, every birth of a grandchild, every death of a beneficiary, every significant change in your assets, each of these is a trigger to review and potentially update your beneficiary designations, your trust, and your overall estate plan. Mistake 5. Doing nothing because it feels too complicated or too expensive. The 5 methods I have described today range from completely free to a few $100s. The cost of doing nothing, in court fees, attorney fees, probate delays, and emotional burden on your family, is almost always significantly higher. Complexity is not a reason to avoid this. It is a reason to get started today with the simplest step available to you. Here is your action plan. 5 steps, this week. Step 1. Call every bank where you have an account and ask whether each account has a payable-on-death beneficiary on file. If it does not, add one this week. If it does, verify the beneficiary is still who you want it to be. Step 2. Contact every financial institution where you have a retirement account, 401k, IRA, 403b, and request your current beneficiary designation on file. Review it. Update it if necessary. Make sure you have both a primary and a contingent beneficiary named. Step 3. Pull your deed from your county register of deeds. In Winston-Salem, that is the Forsyth County Register of Deeds, available online at forsyth.cc, and verify how your property is titled. If you own jointly, confirm the right of survivorship language is in the deed. Step 4. If you own your home outright and want it to pass directly to your children without probate, talk to a North Carolina real estate attorney about a transfer-on-death deed. The cost is typically a few $100s, and the protection it provides is immediate and significant. Step 5. If you have a revocable living trust, or if you are considering creating one, verify that your major assets are actually titled in the name of the trust, or have the trust named as beneficiary. An unfunded trust protects nothing. A funded trust protects everything. Marcus eventually got his father's estate settled. It took 8 months and cost his family just under $5,000 in legal fees and court costs. He told me afterward that the thing he kept coming back to was how simple it would have been to prevent. Not complicated, not expensive, just something his father never got around to doing. Do not let that be your family's story. If this video helped you understand what your family needs, drop a comment right now. Tell me which of these 5 methods you are going to take action on first. I read every single comment, and your answers help me understand what this community needs most. And if you want to go deeper on how a properly structured trust protects your Winston-Salem home from both probate and Medicaid recovery, that full breakdown is already on this channel. I will link it in the end screen. Watch it before the end of this week. This is not about getting rich. It is about protecting what you already built for the people you love. Assets over excuses. Method 1 is the simplest, the fastest, and the most overlooked tool available to North Carolina families. It is called a Payable-on-Death Beneficiary Designation, POD for short. And if Marcus's father had done this one thing, this single thing that takes 15 minutes and costs absolutely nothing, his son would have been able to walk into that bank with a death certificate and walk out with access to $45,000 the same day. Here's how it works. You go to your bank. You ask to add a payable-on-death beneficiary to your checking account, your savings account, and any other deposit accounts you own. You write down the name and social security number of the person or people you want to receive the money when you pass. The bank updates the account, you walk out. That is it. No attorney, no court, no notary, no filing fee, free. When you pass away, your beneficiary brings a copy of the death certificate to the bank. The bank verifies the beneficiary designation. The money transfers directly. The account does not go through probate. Creditors of your estate cannot reach it. It goes exactly where you said it should go, exactly when your family needs it most. In North Carolina, POD designations are governed by the Uniform Transfer on Death Security Registration Act and standard banking law. They are fully legal, fully enforceable, and completely outside the probate process. But here's where most families make a critical mistake. They either set it up incorrectly, or they make one of 4 errors that send their assets straight back into probate anyway. I want you to know all 4 right now so you do not make any of them. Mistake 1 is naming a minor child as the beneficiary. If your beneficiary is under 18 years old in North Carolina, the bank cannot legally hand them the money directly. The funds will be held until a court appoints a custodian or guardian for the minor, which means you end up in probate anyway for the exact asset you are trying to keep out of probate. If you want to leave money to a child, name a trusted adult as beneficiary with instructions, or use a trust structure that properly addresses minor beneficiaries. Mistake 2 is naming your estate as the beneficiary. Some people do this thinking it is the safe or organized option. It is not. If you name your estate as the POD beneficiary, the money goes directly into the probate estate and is subject to the full probate process, creditor claims, and court oversight. Name a specific person, never your estate. Mistake 3 is failing to update after major life changes. Divorce does not automatically remove an ex-spouse as your POD beneficiary on a bank account in North Carolina. If your ex-spouse is still listed on your account and you pass away, they receive the money. Full stop. No exceptions. Update your beneficiary designations after every divorce, death of a beneficiary, or major family change. Mistake 4 is assuming you already have it set up. Most people have never verified whether their accounts have POD designations. The account you opened in 2003 at a branch that has since been acquired by a larger bank almost certainly does not have one. Call your bank this week. Ask specifically whether each account you own has a payable-on-death beneficiary on file. Do not assume. Verify. Method 2 is joint ownership with right of survivorship. This is one of the most common ways that married couples in the Triad hold bank accounts and real estate, and it works extremely well when it is set up correctly. The critical phrase is right of survivorship. When 2 people own an account or a property jointly with right of survivorship, and one owner dies, the surviving owner automatically becomes the sole owner by operation of law. No probate, no court, no waiting. The asset transfers the moment of death. The problem, and this is a problem I see with Triad families constantly, is that not all joint ownership includes right of survivorship. Older accounts especially, accounts opened 10 or 20 or 30 years ago, may be titled as tenants in common rather than joint tenants with right of survivorship. The difference is enormous. With tenancy in common, each owner's share goes through their estate when they die, which means probate. If you have a joint account with your spouse or anyone else, call your bank this week and ask specifically, is this account titled with right of survivorship? Get the answer in writing if you can. If it is not, ask how to update the titling. Most banks can do this quickly with a simple signature card update. For real estate jointly owned in North Carolina, the deed itself must include language specifying joint tenancy with right of survivorship. A deed that simply says two names does not automatically include survivorship rights in our state. If you are not sure how your property is titled, pull your deed from the Forsyth County Register of Deeds. It is available online. And look at the exact ownership language. If it does not say right of survivorship, talk to a real estate attorney about a correction deed. One more thing about joint ownership that surprises most families. Adding your adult child as a joint owner on your bank account to avoid probate sounds simple, but it makes them a co-owner with full legal rights to that money right now, not just after you pass. If your child has financial problems, creditors could potentially reach your account. That is a risk most families do not realize they are taking. A POD designation gives your child the money after your death without giving them access to it today. That distinction matters. So let me bring this back to Marcus. Method 1. A POD beneficiary on every bank account. Method 2. Right of survivorship confirmed on every joint account. If his father had done both of those things, Marcus would not have spent 8 months navigating probate court and $5,000 in legal fees. He would have walked into the bank the week after his father passed, shown his ID and a death certificate, and walked out with access to every dollar his father worked his entire life to save. 2 methods, 0 cost, 15 minutes each. That is the difference between a family in crisis and a family that is grieving but financially protected. Here is your action from part 1. Do these 2 things this week. Call every bank where you have an account and ask whether each account has a payable-on-death beneficiary on file. If it does not, add one. If it does, verify the name is still correct. Then call your bank about any joint accounts and ask specifically whether the account is titled with right of survivorship. If you own property jointly, pull your deed from the Register of Deeds and check the exact language. That is it for this week. 2 calls, 2 confirmations. Your family is already more protected than they were before you pressed play. In part 2, I am going to show you the 3 remaining methods, including the transfer-on-death deed that lets you pass your home directly to your kids without a single day in court, and the properly funded living trust that is the most comprehensive protection available to Triad families. Part 2 is already on the channel. Watch it right now. I will link it in the end screen and in the description below. And before you click over, drop a comment right now. Tell me, did you know your bank account could be completely frozen the day after you pass? Yes or no? I read every single comment, and your answer helps me understand what this community needs most. Subscribe if you have not already. I break down one NC estate planning trap every week that most Triad families never hear about until it costs them their home or their savings. You do not want to miss what is coming next. This is not about getting rich. It is about protecting what you already built for the people you love. Assets over excuses.